Hello, this is Kevin Thompson. I'd like to welcome you all to the Davis McGrath LLC IP webinar series for January 16th, 2013. Today's topic is trademarks and the likelihood of confusion. We're going to be going for about 30 minutes today. The recording and slides will be posted at the address shown on your screen, which is blog.davismcgrath.com/webinars, where you can also sign up for our webinar mailing list. For those of you who need Illinois MCLE credit, if you haven't already done so, please send your name and ARDC number to me. For those of you watching the recording, and you need Illinois MCLE credit, please send me your name, ARDC number, and how you came to view the recording. Our next webinar is coming up on February 6, 2013 from 12 to 12:30 on the topic of trademark dilution. So today we're going to go through some trademark basics and talk a little bit about trademark distinctiveness and how those factor into the likelihood of confusion test. And then we spent a good majority of our time going through some recent trademark trial and appeal board cases. Some of them are ex parte appeals of application refusals, some are oppositions, and I believe one is cancellation. So just briefly, I know we've covered a lot of this before in some of our prior webinars, but just in case, trademarks range in strength of what we call distinctiveness. The bottom rung is generic terms, which such as aspirin. Descriptive terms are the words that are just merely describe the goods or services. Suggestive terms are ones in which they may take a mental step or so for you to decide that what they refer to. They're more suggestive as opposed to merely describing. And the next up above that are fanciful, coined, or arbitrary terms such as Kodak for photographs, or an arbitrary term would be something like Apple for computers, where it has no particular meaning in the context of computers. It's a regular term just arbitrarily used for that. It factors into the likelihood of confusion test in a couple different ways, but it's important to keep in mind, the strength of the mark when you're looking at trying to evaluate things. There are 13 factors that courts and the Trademark Trial and Appeal Board use when deciding whether or not two marks are confusingly similar to one another, and the first four are the ones that are used most often. This first is the similarity of appearance, sound, connotation, and commercial impression of the mark, and this is where the marks are visually and audibly compared. The next is the similarity of the goods or services, and this is where the actual goods or services between the two marks are compared. And for Trademark Trial and Appeal Board decisions, they're limited by the scope of just what's actually listed in the application or registration. Next is the similarity of trade channels. This is like comparison of how the marks might be seen or put into commerce, into the stream of commerce. Just what channels that they might be in. If could be that they're similar channels or quite different, and a lot depends on the facts. The next is the conditions under which sales are made, whether these are impulse or sophisticated purchases. Sophisticated purchases generally allow for more similarity of the marks. But there are a bunch of other factors as well. There are 13 in total. So just looking at some of these other factors, one thing that courts may look at is the fame of the prior mark. The number and nature of similar marks used on similar goods, the nature and extent of any actual confusion that might be found, the length of time during and conditions under which there has been concurrent use, the variety of goods on which the mark is or is not used. This is where a house mark, might come into play. We'll see one of those. It's one of the cases we're going to be talking about. Next is the market interface between the applicant and the owner of a prior mark. the extent to which the applicant has a right to exclude others from use of its mark on its goods, the extent of potential confusion, such as whether there may be de minimis confusion, going on between the parties, or whether it's like substantial confusion. You're able to point to real life, confusion there, and then any other established fact that's probative of the effective use. That factor isn't used very often, but it's there in the test, and it certainly could come up from time to time, and that's where a court or the board could shoehorn in some other factor that's important based on the particular facts of the case. And so here we're going to take a look at some trademark trial and appeal board cases. This would be a good time to point out that at any point throughout, if you have questions, the software allows you to ask it and raise your hand, and I'll do my best to answer as we go along. Otherwise, there will be a question and answer session at the end. And those of you watching the recording, please feel free to call or email me with your questions. The first case is sort of an interesting one. There is a cancellation petition that was filed by the owner of the mark, the U.S. Chamber of Commerce. You might think that that's a government entity, but it is not. It's a private group, and it had sought cancellation of another registration that was already on the registry for the mark United States Hispanic Chamber of Commerce. And there's a lot of issues in this particular case. The opinion goes on for 107 pages, which is unusual. Most board decisions are done in 12 to 15 pages, so this one goes on for 107. So that should tell you that there's a lot going on here, and there's a lot of evidence. Essentially, there was a petition to cancel. There was a counterclaim for genericness of the mark that was used to oppose this U.S. Chamber of Commerce mark. And along the way, the respondent's mark, this United States Hispanic Chamber of Commerce mark, was canceled on its own for failure to file a Section 8 affidavit of continued use. And the opposer was given the option, whether or not to get a default, or whether they still wanted a decision of the merits. They decided to go forward. So just going through this case is great because it goes through a lot of the factors in the DuPont test. The one it starts with is the second, which is the services, and it certainly finds the Chamber of Commerce series services that the registrant provides are certainly related to the association services that the petitioner provides. And it should be noted that the petitioner's registration is not limited to Hispanic businesses. It certainly could cover the same. That they could certainly appeal to Hispanic businesses as well. So this certainly found that they were related, and so this factor weighed in the favor of the petitioner. The next thing they looked at is the trade channels. Certainly these were related, and then they looked at the conditions of purchase. Although they certainly would have been done with dealing with businesses. That they both certainly appeal to the same, and if anything, this particular factor was neutral. And then they looked at the fifth and sixth factors, with both relate to the strength of the petitioner's mark. The first is fame, and that they did find that the U.S. Chamber of Commerce is a well-known mark and had to certainly obtained a certain degree of fame. But the sixth factor, looking at the strength of the petitioner's mark, they found it rather weak. It's composed of common terms, and while they weren't necessarily generic, so their counterclaim for cancellation was denied, but they were still quite weak, and so therefore, the term was not a strong one, and so this, in terms of, well, one factor finds fame, the other finds weakness, and so they sort of effectively cancel each other out in this particular case. Which next gets to the factor that's often addressed first, but they chose to address it fifth, is the first factor, which is the similarity of the marks themselves. I should have noted that the design mark on the right, the applicant had disclaimed its words "United States Hispanic Chamber of Commerce" as being descriptive, and so really all its registration covers is the design itself. And while the applicant, the petitioner's mark is for words, it conceivably could look like the design on the right. So that certainly was possible. But the dominant feature is the design element of the mark on the right. And the board looked at the appearance and connotation of the marks. They looked at U.S., that's on the left mark, and then United States spelled out on the right, and also the use of the word Hispanic on the mark on the right would certainly aid in distinguishing the marks. They tried to introduce some deposition testimony in which they showed the parties at one point during their proceedings had been confused. But in all reality, the board noted that it was more likely than not that the person being asked the question about the different companies didn't understand that the questioner, had moved on from talking about his own company and was now talking about the petitioner, and so that's why he was confused, as opposed to not necessarily having the marks confused themselves. And so, if anything, they sort of discounted that evidence. Particularly, the board noted that since these elements in both marks are weak, weak marks are generally given only a very limited scope of protection. They then tried to point out some minor cases in which the parties have been actually confused. There was some misdirected mail between the two entities. But in all reality, the board looked at it and said it's really just de minimis types of confusion. And then what was really telling is that they looked at what is the effect of whether there's any market interference between these things, these two entities, but there's no evidence of that. Instead, the respondent, the Hispanic Chamber, was able to point to evidence in which the U.S. Chamber of Commerce and the Hispanic Chamber of Commerce had worked together for a long time and were frequent collaborators together on certain projects. And so, since they had this history of working together, ultimately, this factor weighed in their favor, and ultimately the board found that there was no likelihood of confusion and denied petitioner the cancellation petition. But since the registrant's mark, as I mentioned at the beginning, had been canceled on its own, the mark remains canceled. But the petitioner did get its day in court. It's just it would have lost if the mark wasn't already canceled. So I thought this was an interesting case because it goes through all the factors. Admittedly, the opinion itself is quite long. Like I said, it's 107 pages, but it does a good. It's interesting reading because it goes on to explain a lot of the factors and how they certainly might be applied in other situations. Our next case is another proceeding. This one is an opposition. It's an opposition to a pending application, and the applicant is a company called MotoZone, and they've got two applications for retail store and online retail store services featuring motorcycle parts, and repair and maintenance services for motorcycles and ATVs. And so that's what they do. Now, there is the family of AutoZone marks, which was brought by AutoZone Parts Inc. is the person filing the opposition, and they are this nationwide chain of auto parts stores, and so they have multiple registrations. In fact, they've got 11 that are of record in this particular opposition, and I've only focused on one of them here, just the one dealing with retail store services in Class 35. It was interesting in this particular case that the applicant MotoZone stipulated that the AutoZone mark was famous. I'm not sure why they did that, but they agreed to that. And looking at the fact, the board looked at the similarities of the marks. They do appear similar and they sound similar. They both end with the same 6 letters, the T-O-Z-O-N-E, and they would certainly be pronounced the same. That they sound, with the same syllables, the toe zone. And the marks are, essentially substantially similar. Auto versus moto, they have similar meanings. Auto certainly, refers to, all types of automobiles and could cover motorcycles. And, moto and auto are certainly, related technologies. The services were identical. They both covered retail store services, or were closely related. This repair and maintenance services were certainly related. They would cover similar trade channels, in that both of them would deal with consumers needing parts for their vehicles. And so, this factor favored AutoZone. Interestingly, the applicant, MotoZone, at this MS Motorsports LLC that's doing business as MotoZone, tried to argue a couple points that didn't hold sway at all. They first tried to argue fair use, but that's not relevant in a board proceeding because infringement is not at play here. All that can be decided in a board proceeding is whether or not somebody's entitled to registration, not whether or not someone is infringing somebody else's mark. And so as a result, fair use, it doesn't really come into play because fair use would be a defense to infringement, which isn't an issue. And the second argument they tried to make was sort of an unclean hands type of argument that that the plaintiff was trying to monopolize the word zone, by filing multiple oppositions and cancellations against other people that just included the word zone in their marks. But again, that's not relevant in a board proceeding. It has no, play on whether or not, AutoZone is, entitled to maintain its registration or not. So ultimately, the opposition was sustained, and the applications for MotoZone were both refused. The next one is a sort of interesting one, in that the application is for Paycom, and the mark that was cited against it is Paycomp, which was a Workers' Compensation Insurance Administration Services in Class 36, where Paycom is for payroll services in both 35 and 36. And while the services are similar and closely related, this one came down to the meaning between com and comp. The examiner argued that com means compensation, and so therefore had the same identical meaning between the two. But the applicant was able to put on record other definitions of the word com, including one in which com means commercial organization. And the examiner argued opposite, but the board seemed to follow the applicant here and pointed out that this other meaning could apply. And since the purchasers of payroll and workers' comp administration services are both sophisticated consumers, they could certainly find the way between the two. And the refusal was reversed. And in this case, the applicant was entitled to register. It certainly is an interesting decision, and it has been criticized, in the sort of practitioners forums. That a lot of people think that the examiner was probably more correct than the applicant, but that's not how the case came out. So it is what it is. The next one is another interesting one. This one is relating to perfumes, but one of them, the applicant, is for retail store services featuring perfumes, and their mark on the left is Perfume Paris with the design of an Eiffel Tower, whereas the registered mark that had the application was denied, the examiner had cited against, was this Paris Perfumes with sort of a stylized, it's almost a vapor like image above the words Paris Perfumes, and that's for distributorship and services in the field of perfumes. The board noted that there was limited evidence that distributorship and retail store services would have been provided by the same entity. They're normally rather distinct. Distributorship services are generally provided, to businesses, where retail store services will be provided to individuals, and so there'll be completely different channels of trade. And so the board focused on that, and when and as part of the reason that they came to their decision. And then looking at the marks themselves, although that they do use both use the words perfume and Paris, the dominant element of the mark on the left would be the design element of the Eiffel Tower, and there certainly is something to be said for the design of the mark on the right with the sort of the vapor image that's there, and so there certainly did have different commercial impressions, and since the channels of trade were different, the board went forward and reversed the refusal and allowed the application to proceed. So I thought this was an interesting one, and that the design element and also the different channels of trade so certainly played a factor here. The next one is for an application on the left for 3D Clean, brought by Benedent. Brought by Benedent. Benedent is just the name of the proceeding. And they brought an application for electric toothbrushes. Well, there was an existing registration for 3D White for manual toothbrushes in Class 21, and the goods are certainly related, if not identical. There's plenty of evidence that somebody providing manual toothbrushes might also provide electric toothbrushes as well, and so they certainly were related. And then just looking at the marks themselves, they both use the word 3D, and then clean and white are both terms that are commonly used in relating to tooth cleaning. And so there certainly would be similar enough in the minds of consumers. And so in this case, the refusal was affirmed. Oh, I've got a question for Mr. Beiser. The question is, what are the dates for these opinions presented? These are ones that were all within the last 6 months. I believe the earliest one is from September, and there is one, I believe, from December here. So from September to December of 2012. I'm not sure. One of them may have been actually January of 2013. I'd have to look. But copies of all the decisions, when I post the webinar, I'll have copies of the decisions there as well, so people will be able to read the actual opinions. But also the numbers that I've given there, like the serial number and so forth, are ways that, if you really wanted to in the meantime, pull up copies. But I will be providing copies of all the opinions as part of the materials. The next case is another interesting one with competing real estate services. The application on the left for Housing Angels is for real estate acquisition services and real estate investment, and real estate services to help stop foreclosure. And it's more related to somebody coming in to buy houses that are in foreclosure. They're called Housing Angels, and they were refused for this registration for on the right for Property Angels for real estate agent in Class 36. And actually, there was two different refusals in this particular case. First, it was a merely descriptive refusal. That Housing Angels was merely descriptive of someone who comes in and acts as an angel investor to purchase housing. And it was found to be merely descriptive. But then turning to the next refusal, which was, the likelihood of confusion, which is relevant to us here, they both, use the word angels and as the second word, and housing has a similar meaning to property. And the services were highly related. They're both related to real estate. Admittedly, one's for an agent, the other one is more angel investment in foreclosure property, but they're certainly related. There's no restrictions in the channel of trade. They certainly both, could be, offered to the same type of consumers. The applicant tried to argue that they were sophisticated purchasers. These people, with these, these large transactions, they wouldn't necessarily be confused, but the board noted that even sophisticated purchasers could be confused in a moment of weakness. Perhaps even someone getting their house foreclosed on may not make as much of a distinction as they would otherwise be between two entities, and so this factor is relatively neutral, or the board found that they could even perhaps slightly be in favor of confusion. And so weighing all these elements, focusing primarily on the similarity of the services and the marks themselves, the refusal was affirmed. The next case is called In Re Fourth Wall Restaurants, and the applicant had brought their mark is for bar and restaurant services provided in the style and motif of a Polynesian supper club in Class 43. And there were two registrations, both owned by the same company, for their restaurant services. They've got two different design marks. They both use the same flag, this flag with red with a black square in the middle. One of them is just forming the eye in hurricane, and the other one is hanging from a tree to the left of the word hurricane. But it's for the same restaurant, Hurricane Grill and Wings. And that their services are for restaurant and cocktail lounge services, and one of the second one also covers takeout restaurant services. Certainly the services were similar on similar trade channels and potential customers. Looking at the marks themselves, the first factor here in the DuPont factors, the board found that the words on the marks on the right were more dominant than the designs. They tried to show that there was weakness of the word hurricane. But the fact remains that hurricane in itself is an arbitrary mark when used with restaurants. and there's nothing requiring hurricane to use there. That they tried to show that hurricane had special meaning with the state of Florida. That people might come to expect Florida to be called a hurricane state, and so forth. They might have some other element, but they weren't swayed by that. And the applicant also tried to show a significant number of third-party uses of the word hurricane for other restaurants, and essentially that particular factor was neutral. It was just not determinative that that the general public had associated the word hurricane with any one restaurant or so forth. It just was not a determinative enough factor for the board here, and so this particular refusal was again affirmed. Here's another one that's it's kind of interesting. The applicant has a mark called Drill Wizard, which is for athletic training equipment, which is a computerized control that was sold as a component for a ball delivery training machine, and so it's a rather sophisticated component of a larger training machine. And so Drill Wizard is the computerized controls, and it was initially refused due to registration for the mark Shot Wizard for basketball training devices, which were devices placed over basketball rims to aid in shot training. And this decision had a lot to do with the goods and less to do with the marks. The athletic training equipment, this computerized controls, so certainly were related. They certainly both could be used for basketball. The applicant's mark was sold as a component of a larger piece versus, the registrant's mark was a mechanical device put over the rim. There was no evidence that the similar products would necessarily emanate from the same source. I mean, the board focused on one decision that had come out where a mark, they both could have been used for flashlights or for light devices, and so the mere fact that both devices emanated light did not necessarily mean there'd be confusion between two different types of goods that produce light. So that was an important case that they looked at here. And looking at the sophistication of the purchases, Drill Wizard is part of a component for a machine that would cost between $5,000 and $6,000, versus the Shot Wizard, which is I believe that they found that was marketed for $99.95. So certainly completely different markets here, and they are it's certainly different there. You look at the marks themselves, both use the word wizard, and since Drill Wizard related to computerized controls, the board found that the connotation of wizard in that context provided a different look and feel for the Shot Wizard, which was this sort of training aid, sort of a different connotation of the word wizard. And so that and the difference between the word drill and the word shot, allowed the marks to be more readily distinguished. And since the other factors, the other DuPont factors were relatively neutral, the refusal was reversed. And so again, this application was allowed to proceed. Our last case here is the applicant had applied for the mark My Big Fat Greek Wine, which is for wine in Class 33, and whereas there was a registration in place for restaurant services for the mark My Big Fat Greek Restaurant, shown in the design format shown here. Interestingly, both have disclaimed the words Greek wine and Greek restaurant, so the only thing distinctive about both of them would be My Big Fat, which brings to mind the movie, but the board actually never talks about that in their decision, interestingly enough. Looking at the marks themselves, the marks are, highly similar. certainly find that wine and restaurants could be related, and that wine might be served in restaurants. And so certainly there's plenty of cases that show when the marks are close, the relatedness of the two marks need not be as close. And there was certainly no evidence that restaurants do necessarily, while they may serve wine, there's no evidence that the restaurant would, necessarily bottle its own. So certainly it's possible, but it wasn't likely. And there was no restriction on the markets here. They both could be in the same geographic areas. Actually, the applicant made a big deal of the fact that they were completely across the country from the other, but that really doesn't matter. It's for this type of proceeding, whether or not somebody's entitled to registration or not. The registration is presumed to cover the whole entire United States, regardless of whether or not the fact that they may actually do that there. And so, just looking at the similarities of the marks themselves, since they were similar enough and they certainly had some relatedness, even though they weren't as close as they might not necessarily have to be, if the marks weren't as similar, they, affirmed the refusal. And so that particular mark was denied. So this is probably a good point to get into questions. I believe there is a question already, but let me go ahead and just simply say that if you do have a question, now would be a great time to do so. There is a software that will allow you to raise your hand and ask the question. For those of you watching the recording, if you have any questions, please feel free to call or email me at the address shown on your screen. 1 second, let me pause to read the question that's already been presented. The question is whether or not the DuPont case that I've mentioned applies primarily to trademark trial and appeal board decisions, or does it also apply to Lanham Act litigation? And the thing is that these particular factors have been adopted by courts, but they wouldn't necessarily cite these factors from the DuPont decision. In fact, what's often the case is what you'll need to do if you're filing a brief in a particular jurisdiction, you would need to find the case for your jurisdiction that implements these particular factors, and but these are the factors that have been adopted, and while there might be small variations from jurisdiction to a jurisdiction in actual Lanham Act litigation, these particular factors I would say are in 99.9% of them. So I hope that answers your question. Are there any others? Well, I'm not seeing anybody else with their hand raised, so we'll go ahead and presume nobody else has any questions this time. If something comes to you, please feel free to call or email me. Again, thank you everyone for attending. As a reminder, our next webinar is coming up on February 6, 2013, again from 12 to 12:30, on the subject of trademark dilution. Again, those of you needing Illinois MCLE credit, if you're watching the recording and you need to get credit, please send me your name, ARDC number, and how you watched the webinar and when you did so. Otherwise, I wish everybody a great day.